Pierce versus the Society of Sisters is a landmark case about the fundamental constitutional right of parents to direct and control the upbringing and specifically the education of their children. The Oregon law that was at issue in Pierce was quite candid about what it was trying to do. It was trying to make sure that all children would be given a standardized, homogeneous, assimilating education, and to break down the ties that immigrant children or Catholic children might have to their own backgrounds. And this is what prompted the Society of Sisters, who are a religious order who ran a parochial school, to object to the law. The exact question before the court in Pierce is interesting to untangle. So on the one hand, it could be said that the question is, do the sisters have the right, given their operation of these parochial schools, to bring a challenge to the law, since after all, the sisters weren't parents of kids who were going to school? And the court says, yeah, they do, because they do have interests at stake. But for our purposes today, the enduring question that was raised and answered was whether the state's power to regulate education goes so far as to permit them to outlaw entirely parents' decisions to select private schools. For Pierce, who's the governor of Oregon, he's defending Oregon's law. He says public education is important for democracy. States have long had the power, the so-called police power, to regulate the health, safety, welfare, and morals of their people. And, Pierce insisted, providing universal public education and insisting that it happen in public schools was a permissible way to advance the government's goals. The Society of Sisters conceded a lot of that. They could concede the importance of education, and they could concede the power of the state to regulate education. But what they did on behalf of parents was to insist that a flat-out ban on private education or on religious education went too far and infringed on parents' liberty to try to direct the formation of their children. The court, when confronted with this Oregon law that purported to outlaw all private schools in the states, said the law couldn't be enforced. There aren't any recorded dissents. Justice McReynolds' opinion in Pierce is short and sweet by today's standards, in part because he's able to rely on the Meyer case, which had been decided just 2 years before. Meyer versus Nebraska involves a state law which purported to prohibit education of primary school children in languages other than English. The purpose of the law was probably to target children who were attending parochial schools and often receiving instruction in German. The Supreme Court insisted that parents retain the right to educate their own children, to select the education that works best for their children. In Meyer and Pierce, when the court is asking whether the right at issue in those cases, the right of parents to educate their children, is that part of the liberty protected by the 14th Amendment, the justices don't consult their own policy preferences, and they don't consult polls or public opinion measures. Instead, the court looks at its own precedents over time, and it looks at history, tradition, and practice, and deeply rooted understandings. So the methodology for identifying those unenumerated rights that the 14th Amendment protects is one that still requires courts to be relatively restrained and modest and tethered to America's longstanding traditions and sort of unfolding story. Sometimes Pierce and Meyer have been used in the decades since as kind of a license for justices to create new rights or to change the Constitution with the times. But that isn't what the justices thought they were doing in those cases. They thought they were identifying and vindicating a deeply rooted right that the 14th Amendment itself had merely recognized.